Welcome to some special relationships that apply throughout inheritance law, whether it be a will, a trust, or intestate succession. But first, let's make sure that we have a review of intestate succession, understanding that what we are trying to do is define a decedent's heirs, who are generally blood relatives who survive by a statutory period of time, that there is a very direct roadmap of who the heirs are, and you start with the spouse, which is a blood relative exception. If someone has a spouse, that spouse will inherit. Next, you look to the category of issue and descendants, which include children and grandchildren. And to the extent they take by representation in Maryland, that means by the roots. Under the UPC, that means by the head at every generation. So a grandchild who is inheriting will inherit the same regardless of whether or not they're an only child or one of six. Only to the extent you have no issue would you move on to the ancestor, a parent. If the parent or parents did not survive the intestate, then you move to the issue of the parents, which is a collateral, someone related to the intestate through a common ancestor. They too take by representation. Maryland and the UPC dividing at the level where you find a survivor, and then at that point, the deceased collateral share go to the issue of the collateral, whereas the UPC combines and redivides. It's only after you go through the parents and the issue of the parents, the grandparents and the issue of the grandparents do we get to the stepchild, which again is another blood relative exception before the property will escheat, which means that it goes to the state. Unique to intestacy is the idea of advancement. It has to be written acknowledgement. Just writing them a check would not be enough, and it will offset their intestate share. We're going to move on to special relationships that apply to inheritance in general. The non-marital child, the adopted child, the child born as a result of genetic material. All of those issues generally treat these special relationships as if or the same as a natural or biological child. First, we look at the half-blood. A half-blood is someone that is related to the intestate or testator. Remember, these are broad concepts, through one parent, whereas a whole blood is related through both parents. They will take the same. They will be treated the same, unless otherwise indicated in the will, but certainly they are treated the same for purposes of intestate succession. Adopted child. Well, an adopted child has no blood connection at all, yet through a separate statute is surgically inserted into the adopting parent's family tree. They are treated exactly the same as a natural or biological child. The Estates of Donnelly shows that an adopted child severs the ties to the natural family. They become surgically inserted into the adopting parent's family tree. And even though that may not have been the intent in the Estates of Donnelly, that is exactly what occurred. But shouldn't there be an exception called a step-parent adoption? It makes no sense for someone who is married to the natural parent for that natural parent to be eliminated. And in that case, there's something called a step-parent adoption, in which case Jean Louise would be able to take from her natural mother, Faith. Secondly, we take a look at the Britton case. And what that demonstrates is that there's no difference between a child adoption and an adult adoption. Historically, before they allowed same-sex marriages, partners would adopt each other to prevent families from contesting wills and things of that nature, because they would be treated as a descendant and would be the first to inherit. This was an adult adoption, and there's absolutely no problem. There's no requirement that an adoption take place when the individual is a minor. One thing I will mention, though, it's not easy. It's virtually impossible to unadopt. So once you adopt someone, they become part of your family tree. What about the non-marital child? This is something that is also tested. A non-marital child is treated the same as a marital child. It is possible jurisdictions are permitted to require a non-marital child to prove paternity, but otherwise they take the same as a marital child. This was addressed in the Supreme Court case of Trimble v. Gordon. And whenever you see a jurisdiction in which the states are trying to treat non-marital children different from marital children, then you could argue that that would be unconstitutional. I mean, trust in estates does not get that many Supreme Court cases. This happens to be one. It hit the bar exam in 2010, July, question 3. You could take a quick look at that. Genetic material, another one. I've never seen it tested on the bar exam yet, but as long as you go through the steps and you have the consent and they are born within the 2 years, a an individual, a child born as a result of genetic material will be treated as the same as a natural child for purposes of intestate succession, wills, or trusts.